As schools grapple with issues of student safety and drug use, some administrators have turned to personal searches of students as a means of enforcing school rules. However, these searches can be controversial, with many arguing that they violate students' Fourth Amendment rights, which protects citizens from unreasonable searches and seizures by the government. This means that the government cannot search a person's property or seize their belongings without a valid reason or a warrant or court order, except in certain limited circumstances, such as in case of emergency or if there is probable cause to believe a crime is being committed. In the context of personal searches of students by school administrators, the Fourth Amendment protects students from unreasonable searches and seizures and requires that any searches be conducted in a reasonable manner with a legitimate purpose. In this video, I'll introduce two Supreme Court cases that have addressed the legality of personal searches of students by educational administrators. The first case is a landmark decision by the U.S. Supreme Court, which established the standards by which public school officials can search a student in a school environment without a search warrant, and to what extent. In New Jersey v. TLO 1985, two 14-year-old freshmen were caught smoking in the girls' bathroom by a teacher, in violation of school rules. While one student admitted to smoking and was assigned to complete a smoking clinic, the other, known by her initials TLO, denied ever smoking. The vice principal demanded to search the student's purse and found cigarettes and rolling paper in plain view. This prompted a more thorough search, which turned up a small amount of marijuana, a tobacco pipe, an index card with the names of students who owed her money and two letters linking her to dealing marijuana. The vice principal notified the police and the student's mother, and the student was convicted of drug dealing and use. This led to her expulsion, $1,000 fine, and criminal charges. However, the student fought the charges on the basis that the search of her purse violated her Fourth Amendment rights. The case went through several courts before reaching the U.S. Supreme Court, which ultimately ruled in a 6-3 decision that the search of the student purse was constitutional. The U.S. Supreme Court held that the Fourth Amendment prohibition on unreasonable searches and seizures only partially applies to searches conducted by public school officials, and the search of students' purse was reasonable. Unlike with law enforcement officers, school officials do not need probable cause or a warrant before searching a student. Rather, they must have reasonable suspicion that the student has violated either the law or school rules. Reasonable suspicion means that school officials must have a belief based on specific and articulable facts and logical inferences from those facts, indicating that the student has committed or is about to commit a crime. Reasonable suspicion is a lower standard than probable cause and allows for a limited search or seizure of a person or property. Reasonable suspicion is in place to ensure that school officials act based on evidence rather than personal biases or unsupported hunches. It's often used by school officials to investigate suspicious activity or behavior. It allows for a limited search or seizure of a person or property, such as a pat-down search or a search of students' backpack. Probable cause is a higher legal standard that requires a reasonable belief that a crime has been committed and that the person or property to be searched or seized is connected to that crime. It allows for a more intrusive search or seizure of a person or property. Probable cause is often used by law enforcement or school officials to obtain a search warrant or make an arrest. The main difference between reasonable suspicion and probable cause is the level of certainty required to justify a search or seizure. Reasonable suspicion requires a lower level of certainty than probable cause and allows for a limited search or seizure. Probable cause requires a higher level of certainty and allows for a more intrusive search or seizure. For example, if a school official sees a student acting suspiciously, such as hiding something in their backpack or locker, the school official might have reasonable suspicion to search the student's backpack or locker. However, if the official has evidence that the student is planning to bring a weapon to school, they would need probable cause to search for any weapons or other evidence that might be relevant to the planned crime. In this case, the Supreme Court found that the search was reasonable because the school official had a reasonable suspicion that the student was carrying cigarettes in her purse, and the discovery of rolling papers in the purse provided reasonable suspicion that the student was also carrying marijuana. The Supreme Court also found that the scope of the search was reasonable based on the evidence that was discovered. Justice William Brennan, joined by Justice Thurgood Marshall, had a different opinion than the majority on how to handle Fourth Amendment protections for school officials. While he agreed with the majority decision, he dissented from the new standard set down by the Supreme Court. In fact, he thought it was a departure from the traditional probable cause approach. Brennan wrote, "Today's decision sanctions school officials to conduct full-scale searches on the reasonableness standard, whose only definite content is that it is not the same test as the probable cause standard found in the text of the Fourth Amendment." In adopting this unclear, unprecedented, and unnecessary departure from generally Fourth Amendment standards, the court carves out a broad exception to standards that this court has developed over years of considering Fourth Amendment problems. Its decision is supported neither by precedent nor even by a fair application of the balancing test of power it proclaims in this very opinion. Safer Unified School District v. Redding, 2009, is another U.S. Supreme Court landmark decision on personal searches of students. This case highlights the importance of balancing students' privacy rights with the school officials' responsibility for maintaining a safe and drug-free environment. In 2003, an assistant principal of a middle school in Arizona asked a 13-year-old student, Savannah Redding, to come to his office. The assistant principal showed Redding a day planner which had several knives, lighters, a permanent marker, and a cigarette inside, and he asked if it was hers. Redding stated that the planner belonged to her, but not any of the items inside. She also stated that she had lent the planner to her friend, Marissa Glines, a few days beforehand. The assistant principal then showed Redding 4 white prescription-strength ibuprofen 400 milligram pills and 1 over-the-counter blue naproxen 200 milligram pill, all used for pain and inflammation, but banned under school rules without advanced permission. The assistant principal informed her that someone had reported her for distributing these pills to other students, which Redding denied. Redding agreed to let the assistant principal and an administrative assistant search her backpack, which did not reveal any pills. At the assistant principal's direction, the administrative assistant then took Redding to the office of the school nurse, where the administrative assistant and the school nurse asked Redding to remove her jacket, socks, and shoes. They then asked her to remove her t-shirt and stretch pants, neither of which had pockets. Finally, Redding was told to pull her bra out and to the side and shake it, and to pull out the elastic on her underpants, thus exposing her breasts and pelvic area to some degree. The search did not reveal any pills. A week before Redding was searched, another student had reported to the assistant principal that drugs and weapons were being brought onto campus and that he had become sick after taking pills obtained from a classmate. Earlier on the morning of Redding's search, the same student gave the assistant principal a white pill, later identified by the school nurse as prescription strength ibuprofen, and told him that other students were going to take the pills at lunch. The student claimed that Marissa Glines had given him the pills. He also told the principal that he attended a party at Redding's house at which alcohol was served to his peers. When the assistant principal searched the Glines out of class and in the presence of the administrative assistants, asked her to turn out her pocket and open her wallet, which produced a blue pill, several white ones, and a razor blade. Glines identified Savannah Redding as the person who had supplied her with the drugs. When the assistant principal asked Glines about the day planner, she denied knowledge about its contents. The assistant principal then instructed the administrative assistant and the school nurse to search Glines' bra and underpants, which revealed no additional pills. It was at this point when the assistant principal called Redding into his office. Redding's mother filed a lawsuit against the assistant principal, the administrative assistant, the school nurse, and the school district. The lawsuit claimed that the officials conducted an unreasonable search on Redding, violating the Fourth Amendment. The district court ruled in favor of the school officials, citing qualified immunity. However, Redding continued to fight the ruling and appealed to the U.S. Court of Appeals for the Ninth Circuit. In 2009, the U.S. Supreme Court heard the case. 7 justices, all but Justice Clarence Thomas, agreed that the strip search violated Redding's Fourth Amendment rights. Justice David Souter delivered the opinion of the court. Justice Souter explained that schools only needed a reasonable suspicion to conduct a search, not the higher standard of probable cause used by law enforcement officers. In this case, the school officials went too far by conducting a strip search, which is a very invasive type of search. The content of the suspicion failed to match the degree of intrusion. Strip searches require a higher level of justification and are only justified if there is a serious safety concern. In this case, the assistant principal did not have a good reason to suspect that Redding had drugs hidden in her underwear, so the strip search was not reasonable and violated the Fourth Amendment. For these reasons, the strip search of Redding was unreasonable and violated the Fourth Amendment. For school officials to conduct a strip search, 2 factors are key. First, the item in question must present a threat. And second, school officials must have a reasonable belief that the item is located in the student's undergarments. A strip search may be justified in situations when there is an immediate threat to student safety. For example, if there is a credible report of a student bringing a weapon or a dangerous drug onto campus, and there is reason to believe that the student may have hidden the item in a way that can only be discovered through a strip search, school officials may be justified in conducting one. While school officials may conduct searches of students under certain circumstances, they must have a reasonable suspicion and ensure that the search is not excessively intrusive in light of the age and the sex of the student and the nature of the infraction. The court has clarified that strip searches should only be conducted where there is a reasonable belief that the item being searched for presents a threat and is located in the student's undergarments. It's important for school administrators to keep in mind that students have a reasonable expectation of privacy and that personal searches should only be conducted as a last resort when less intrusive methods have failed. Ultimately, school officials must balance the need to maintain a safe and secure learning environment with the constitutional rights of their students.